First of all, I don't necessarily agree that the threshold is low for the question of determining whether or not a committee ought to be put in place to investigate and, in fact, test whatever allegations are being made. Because if we continue to view the process as starting and ending when the president makes a prima facie determination, would be led into that thinking. One of the first times I discovered was based on the article you had written as to the first person this was exercised against, James Opon, or I think...
Yeah, James Opon.
James Opon.
Deputy
Jacob
NCC.
Opon.
Jacob Opon, correct.
The allegations against them that went to the Supreme Court was one, that Larry Bimi then, as chair of the NCC, had asked him to swap offices, which he refused. And the second one, that he had made a sexual advance in respect of a staff. The Supreme Court considered that these were grounds which are sufficient to meet the standard of misbehavior. This was the Supreme Court's decision. Okay. Now, we are all trying to avoid going into conversations around what the petition entails. It is very difficult for me to say that the Chief Justice, allegations of financial impropriety were made, irrespective of whether or not the persons have provided proof, because that's for another process. The Chief Justice has been engaged in removing and transferring judges of the Supreme Court for reasons other than administrative efficiency. That it is alleged that it is influenced by other reasons. Whether or not this is proved, it suffices for us to inquire more. That's my question.
So the bare allegations, should be enough.
For me, the allegation, as long as an allegation is credibly made, this is not the point where you have to test and retest the evidence. If we transform the presidency into where he must shift through evidence and give evidential weight, then we are even politicizing the process more than it's required. There's a reason why in one instance it's only a conveyor belt, because we don't want it to be politicized. In this case then, if the Supreme Court has determined, those who can look after themselves, have determined that the president should be involved in determining prima facie case, I do not want a situation whereby, in the same way the president can be displeased with a Chief Justice, a president can be pleased with a Chief Justice who does his bidding, and for which reason he will be interested in keeping that Chief Justice in office. Oh. So if there's another layer of a process, that all those who have made those allegations will come forward and then prove that allegation, then it is fair. I am extremely disappointed, in fact, that the process and the muddying of the waters is being led by the former Attorney General and the Deputy Attorney General. I think that their role in this process has not enhanced the credibility of the process, but only undermined the integrity of how we should go forward. And some of the comments that the Deputy Attorney General was making on there, I am shocked to hear her speak like this. Because all of us here even have known, the wisdom of restraint as to where we want to talk about the process generally, without even going into the substance of allegations and determining on our own basis whether or not that suffices. So some of the positions he has taken, I find them shocking. Even the suggestion that the Chief Justice was a member of a panel, and for which reason we cannot isolate misconduct by one individual in the power, flies against everything that we know in law. The fact that 4 people have been accused of a crime, it is no defense to say that one of them has been brought before a judge, and so for which reason you should be excused from liability. I don't know.
No, but is it not fair to say that they have done something collectively?
The question is...
A decision collectively.
The question is whether or not...
out.
The question whether or not in terms of a collective decision. The question here is not whether or not the Chief Justice was wrong to make a decision. It is interrogating the process by which she made a particular decision. That decision and that determination, we can be sure that Justice Poamang, Justice Asiedu, and the 3 other persons who have been brought on board can reach those decisions fairly and determine that as for this is out or on. But importantly, there are 3 petitions before the Supreme Court. Even though we say there are 3 petitions, in fact, the allegations are more than 3. And so one individual can make several allegations. On one, there might be a prima facie basis. On another, they may disagree. On the other one, the committee might find that, yes, this is a ground enough. On the other one, they might dismiss it. So it is not insufficient to pick and choose the one we think is weakest, and then criticize the entire process of being orchestrated to remove a Chief Justice.
But doesn't Dinah and others have a point? 3 petitions.
Yeah.
I remember in Loretta Lamte's case, there were more than 1 petition.
Absolutely.
Okay. I've heard people say Anodompre and Richard Nyama. No. The petition that succeeded in the prima facie was my client's petition, which is Richard Nyama. So it was only Richard Nyama's petition that was used. Yeah. Anodompre's petition was not used. Forward. How come that all the 3 petitions succeed in prima facie? When, as she looks at the petitions, some of them, they could have thrown them away.
Well, let's look at the 3 petitions from what I understand, because particularly for Professor Kweku Asari's petition, the one that we know of and the allegations that were made in the past, several of the things that Daniel Oforo is alleged to have said are repeated from there. So they are cross-cutting some of the issues raised. The bigger one, if you were to ask me as an individual, the bigger question that I'm a bit concerned about is the one that was made by the police officer in terms of allegations that records of the court were changed and things like that. Without going into evidence, we cannot hear an allegation like that and say that let's dismiss this and throw this away. We must, in fact, interrogate that. And it is possible that the committee might find that the Chief Justice did wrong, but it does not arise to the level of removal. The committee is entitled to do that.
In the performance of their job as judges, is it far-fetched for a judge to see that a lawyer is behaving unruly, is misconducting themselves in a way that they are entitled to call the police to pick them up and detain them? Okay. Is it wrong?
The principle that a judge, where a person's conduct is interfering with proceedings, a judge is entitled to. The principle itself does not obscure whether in the factual circumstances of this case, because the allegations the person is making is not only the impropriety of having been arrested, but also that because I wanted to take further administrative actions, I sought to procure the records of what actually happened and found that these have been changed. That it was, in terms of a search file, it was said that, no, you were never arrested. These are allegations which, again, I am not in a position to prove or disprove. The committee then of senior judges would interrogate this question.
The CJ doesn't have custody of the record.
The question as to...
The records he's looking for. It is those who are manning the CCTV process or recording process.
This is an interesting point then for the committee to then go into. That if you are alleging that the Chief Justice was involved in the process, how was he so involved? When I have gone before a high court, before the record is given to you, they tell you that the judge must look into it first.
That's correct.
I have heard rulings made orally in court because we have stenographers who are typing what the judge is saying. And when you apply for it, it is different from what was read in court. It happens all the time. It happens so many times. They may even change words. Okay. May retain the substance of it.
Okay.
The question now for us is for this body to determine whether the series of conduct is sufficient.
I need to take a break here, but it's only fair to give you a minute or two. What's your final comments?
There's
going to be a demonstration.